So I wanted to talk to you to start off with about something that you do not want to do if you want to be prepared for your custody trial. So a couple weeks ago, a potential client came in to see me. And she came in to see me because she was getting ready for a divorce trial. She was representing herself, and she wanted me to coach her a little bit. And she was really a kind person, but during the whole consultation, I was cringing because she had no clue what the court had ordered in terms of getting ready for trial. So what I want to tell you guys to do is when you're getting ready for your trials, you cannot ignore the court's orders. You have to read all of the minutes in your case, especially the minutes where the judge set your trial. Chances are in those minutes, the judge is going to give you very important information about what the judge wants to see happen prior to trial. So for example, in Arizona, when the judge sets trial, the judge will give us deadlines in the minutes about filing pretrial statements and when they're due. Often the judge will tell us what the judge expects us to include in those pretrial statements. The judge will give deadlines for submitting exhibits to the court. The judge will give deadlines for disclosure and discovery. The judge will give deadlines for disclosing witnesses. And the judge will also say, this is what happens if you don't do any of these things. You may be defaulted. If you miss an issue in your pretrial statement, you may not be allowed to present it. So when I met with this potential client, she had no clue what the judge's minutes said about getting ready for trial. And I was just really scared for her because she just totally missed all the deadlines for disclosure. Her pretrial statement was coming up due in like a day. Because she hadn't disclosed any of her evidence to the other side, she didn't know she was going to be able to use it at trial. And she certainly wasn't, she didn't even have it gathered. So she wasn't ready to put it in the form that the judge wanted to see it. So please, 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 if you're getting ready for a trial, one of the first things you have to do is read the minutes where your court sets the trial. Make sure you are aware of all of the judge's requirements going into that trial, because it freaks me out when people ignore those, and oftentimes it's not a matter of ignoring. You don't know what you don't know. So maybe they don't know that, the court has the requirements it does. But right now, because you're listening to me, you don't have any excuse for not knowing. So go check your minutes. And if there's nothing in the minutes where your hearing is set, and this doesn't just apply to final trials, it applies to any evidentiary hearing, a temporary orders hearing, an emergency hearing, even an order of protection hearing. So you don't have an excuse. Go to the minutes. And if there's nothing in the minutes, then go to your rules of procedure. I hope that makes sense, you guys. So another piece that I wanted to share with you, and I'll give you more details as I get more details. I got contacted by somebody I was coaching, and she found me via Command the Courtroom, and she got a decision in today. And she had been divorced a few years ago. She and her ex were awarded joint custody, joint legal decision-making. And anyways, she believed that her ex suffers from narcissistic personality disorder, and the last few years have been very difficult for her. So she took him back to court to get sole decision-making. And I coached her through the trial process. And she was really, she really dove in. She did her research, and she got her decision today, 21-page decision from the judge giving her sole decision-making, sole custody. So she sent me that decision. I haven't had a chance to look at it, but she gave me permission to share this with you guys. And I told her, you're really a source of inspiration. There's so many people out there who feel like they don't have hope because they don't have attorneys, but you're proof that even if somebody doesn't have an attorney, they can do this. She followed the rules. She gathered her evidence. She prepared her questions, and she was ready, and she got what was best for her child. So I want to remind you that it is possible. Okay.